Welcome everyone to our session today. This is Azami's Community Forum where we specifically focus on life sciences. Today we're going to focus on India, and I'd like to introduce our speaker from K&S Partners, Durgesh Mukharya. Durgesh?
Hi Sharon, good to be here and thank you for having me, and big thank you to you and Azami for having me, and I'd like to share my wisdom with all of you and the audience on life science practice in India, and some peculiarities about it. Just to quickly introduce myself, everyone, my name is Durgesh Mukharya. I am from K&S Partners India. I've been with the firm for 14 years. I'm a partner at their life sciences practice. My background is in biotech. I'm a lawyer, a registered patent agent. And a bit about my firm. We have been around for a while. We are into our 27th year of existence. We have 5 offices across India. I come from the Bangalore office of the firm, which is towards the south of the country. We have close to about 300 people put together across these different locations. We are amongst the largest and most diverse pool of IP attorneys in the country. Also amongst the top 3 filers of PCTs originating from India, which allows us to continuously have exposure to foreign geographies and their laws. We believe in our vision is to become the finest firm in India, finest IP firm in India, and to take us there, we have a defined set of values, which are abbreviated as CLIPS, CLIPS, for client first, learning organization. We do all our work with utmost level of integrity. We care about the people that we have, and of course, we would like to do our bit for the society. As we are an IP boutique, we deal with all forms of IP, and within the respective forms, we deal with advisory, prosecution, transactional work, as well as on the action front, on the protection and enforceability of IP as well. And I'll talk a little bit more about that in coming slides. We have had good fortune to work with clients across domains and across geographies, and as a result, we have a fairly diverse portfolio of patents, trademarks, copyrights, geographical indications, PCT applications. As I said, we file a lot of international PCT applications originating from India. And as I said, we are a very diverse team of attorneys across different domains. And we, within each domain, we have, PhDs and masters to cater to our clients' needs at different stages. Right. So with that, let's get into today's topic. And before we dwell further into the best practices and overview of patent prosecution in India and so on, just a basic kind of roundup of why India, why are we having this session, why has India become important in the global scenario. And just to give you some facts and figures, we are now the 5th largest economy by GDP. We are just behind China as the 2nd most populous country. We are the 6th largest consumer market, which makes us an important destination for goods and services of all kinds, and hence, as a result, IP automatically becomes important and critical. We are 3rd on the list of unicorn startups, and a big share of contain a big share of small and medium enterprises. In the last 5 to 10 years, in particular, there's been a lot of emphasis on innovation, and therefore, we're just behind US and China in terms of the number of startups and how well they've been funded and how well they have been doing. As a country, we've had an average growth of 6 to 8%, which continues to be there, and that's the reason why India has been kind of growing year after year and doing well and becoming a little more important each year from global perspective. In terms of IP, and particularly, I come from patents background, so particularly on patents, we still file a very, very small percentage of global patents, and that's something that has troubled a lot of us practitioners in the field, and we continue to encourage more domestic players to file more patents, and of course foreign players as well. Our patent numbers are not very high. It's just about 56, 57,000 a year. But in the last 5 years or so, there's been a significant increase in the number of examinations that take place. And as a direct result, we have had more patents being granted and more patents being examined than ever before in India. And that is a constant, that's a result of a constant effort from the government, from the IP ecosystem, from everybody involved to make sure that patents are being granted quicker. There's more faith that the applicants from across the world have on the Indian IP system. There used to be a time where everyone used to curse the Indian IP system and say that you have to wait for 7, 8, 10 years to get a patent. That's no longer the case. You are able to get a patent within 2 to 3 years from the date of filing in India. So it's become much quicker. In terms of our economy, we are, in terms of our labor force, about 50% of it is still involved in agriculture. But in terms of the GDP, our highest GDP growth comes from services that we provide to the world. And of course, we have a strong industry presence as well. So with that, we now see as to why patents are important in India, and what's the overall process and how do we go about patent filings in India, and then we'll slowly link it up to life sciences in particular. In general, our overall patent process is similar to most other IP savvy geographies. We start with filings, and I focus this slide particularly for our foreign viewers, because a foreign audience, because that's they form the major chunk of patent filers for India. So for all of you who are interested in filing national phases or Paris Convention filings into India, what you need to do is you need to file with the latest set of PCT claims. When you enter India, there are no amendments that are allowed except for deletions. A request for examination needs to be explicitly filed in India. It's not automatic. And once you file and once you enter the national phase in India or Paris Convention application in India, then of course you're free to make amendments by way of preliminary amendments, depending on what you would like to protect and what you would like to continue with in terms of prosecuting in India. Once you have filed a request for examination, the patent office usually comes back with the first examination report. You respond to it. You get about 9 months, 6 plus 3 months to respond to it. And if the objections are impending, there are still some objections that the examiner is not happy with, then as a second chance, they generally prefer not to issue a second examination report, although that used to be the case in the past. But for the last few years, it has just been the second round has been the round of hearing, which means that they issue a hearing notice, and you basically sit across the table with the examiner, discuss the case, and try to arrive at some conclusion as to what kind of claim amendments the examiner needs, what kind of prior arts, and you basically discuss the case at length. In the last 3-4 years in particular, everything has gone virtual. So now we do these hearings from the comfort of our offices and home. And once everything is sorted with the examiner, the patent goes through to a grant, or if there are still issues that you've not been able to satisfy the controller with, then the patent office refuses the case, and then you have an opportunity to file an appeal at respective high courts. A practice pointer: be mindful of the entity status when you're entering, when you're filing either national phase or Paris Convention applications in India. Whether you're a startup or a small entity or an educational institute, you do get a heavy discount on official fees. The thresholds for startup and small entities are different, but you still get the same benefit. That is, your official fees reduced by 1/5. Reduced to 1/5 rather. Sorry. We do have 4 patent offices, but they now work in unison. It's a centralized functioning now. They try to utilize their resources to the best of their capability. So, regardless of which patent office is the one where your patent is filed, your application is filed, it may be allotted to a completely different patent office for examination. So there is no longer a possibility of forum shopping that used to be the case maybe 10 years back, where you used to file patent applications at a specific office because they had better examiners or faster rate or were more lenient with certain technologies. That is no longer the case now. And everything is online, and it's on real-time module. So you file anything online, whether it's the filing, the documentation, the formalities, everything is uploaded onto their website within a matter of minutes, and you'll be able to see them. Everyone will be able to see them on the Indian Patent Office module. And there are no hard copy requirements any longer. So everything is online. Soft copies are good enough, even for power of attorneys and assignments and everything. In terms of prosecution timelines, as I said, the current estimate is anywhere between 6 months to 1.5 years from filing request for examination to issuance of first examination report, which is very quick considering where we used to be at one point in time. It used to take anywhere between 4 years, 5 years, 6 years to get the first examination report. We have seen cases where we have filed requests for examination, and even within 3 months, 4 months, 5 months, reports have been issued. Even in cases where you have not filed expedited examination. So Patent Office has really come a long way in terms of how fast they are able to prosecute the applications these days. We get 6 months, extendable by 3 months. Of course, early response triggers a quicker turnaround time from the Indian Patent Office. And as I said, hearings are all virtual, and you can adjourn them up to a maximum of 2 times. But the faster you do it, the quicker is a grant. And then once the application is granted, you have the same process of annuities as almost every other country. But in addition, you have a requirement of Form 27, which is also called working statement. And the reason for that is that the Patent Office wants to know each year whether you have been able to work your invention in India or not. And this is a bit of a peculiar provision in India, not very common in any other country, rather. So this is something that you have to be careful about. Form 27 is not a very complicated process, but you would have to give in details like whether your invention has been worked or not, what kind of revenue has been generated, are there different patents that are linked to a product, and so on. So it's best to take help from a local attorney while addressing a working statement requirement year after year, along with annuities. So that was just a quick overview of the patent process in India. Now let's move to some life science specific issues. And for the purposes of this session, I have chosen 3 important issues that usually trouble applicants in India. One is on the inventive step, the other one is on subject matter eligibility, and the third one is on claim amendments. So let's look at the first one, which is on inventive step requirements. And what I would basically be talking about are what are the useful arguments in India, what kind of approach you need to take, and there's a lot of focus on data from the Indian examiner. So how do you go about that? Now, if you look at the basic provision, basic law that's written in the Act in India, it basically says that inventive step is a combination of technical advancement and something which is not obvious to a person's skill in art, which means that there is an equal emphasis on both technical advancement and non-obviousness. Now, we do know as patent practitioners that a lot of countries and examiners worldwide are okay with only an argument as to non-obviousness. And you say that, your invention is non-obvious over the prior arts, and sometimes examiners are good, happy with it. In India, that argument alone, in most of the cases, do not work. Because the examiner says that, okay, even if it is non-obvious over the prior art, is there a technical advantage that you are able to show and associate with that non-obvious feature? So generally, the emphasis is equally placed on technical advancement and non-obviousness. And even if you're not able to show non-obviousness, technical advancement is the more important of the two features that helps you in getting your patents through in India. Some of the approaches that are commonly taken in Europe are also preferred by Indian examiners. As some of you might know, Indian patent law has a lot of its bearings from the European patent law. So you will find a lot of similarities even in the way the examiners approach it, in the way the patent office approaches the legislations, the provisions, the act, and so on. So problem solution approaches, we all know that's the way to deal with prosecution in Europe. And it is true for India as well. You go ahead with problem solution approach, you identify a problem, challenge, or issue faced by the industry or end user, how your invention solves that problem, what kind of technical effect comes out of your invention, and is it able to solve a real life problem? Is it providing a real life technical solution to a problem that is faced by a user or an industry at large? And then how the prior art is maybe different or solving a different problem or is not able to solve this problem. So problem solution approach is works almost every time with examiners. They like the approach. It's easier to explain to them, and it makes our life easier as well when we talk and make the examiners understand what the invention is about. The other one is the hindsight approach. How a person skilled in the art would not be motivated to combine certain prior art documents, maybe because of the differing objectives of the prior arts, the way they teach a particular solution, the solutions that they are trying to reach at, the problems that they are trying to solve, some kind of negative teachings that might be associated with the prior arts, and so on. So you basically try and convince the examiner that at the time of filing or at the priority date of your Indian application, a person skilled in the art would not have looked at these documents for ABC reasons. So that's again a great approach that patent practitioners use worldwide, and this is equally important and helpful from Indian context as well. In terms of data, Indian examiners do like to see a lot of data. They get positively influenced by seeing comparison, by seeing negative data, and sometimes they also allow additional post-filing data. Now, generally, the best kind of data that they are happiest with is comparison of how the present invention fares versus the closest prior art. Now, sometimes this data might already be there in your specification, but if it's not, it's okay to present this after or at the time of prosecution as well, because the examiners fully understand that the closest prior arts have now come up during prosecution, and therefore the applicant is trying its best to defend the invention against these prior arts, and therefore they are generally comfortable with accepting post-filing comparative data. Negative data is again something that is also helpful. Sometimes again present as part of the specification. Sometimes you can submit it as post-filing data on how deviations, changes in elements, choices of concentrations, differences in parameters or conditions make a difference to your end result, whether it's a product, whether it's a process. How do these elements, how do these different aspects make a difference and make an overall impact in your final invention? So data is something which is very important from Indian context, and something that you should be prepared to show the examiner during prosecution, whether responding to examination report or at the next stage of hearing. That is something that they like to see at all stages. The next issue, apart from inventive step, and inventive step, as I said, might be similar to something that you might have dealt with in other countries as well. Subject matter eligibility in India is a slightly more complex issue because there are so many riders here of non-patentable subject matter that it sometimes becomes very complicated to comprehend as to what is patent eligible, what is not patent eligible, and how do we go about it. And out of the 15 odd provisions that we have in India, 80% of them apply to life sciences in one or the other way. So what I've done here is I have kind of collated them as part of this table to make it slightly easier for the audience to comprehend. And what I've tried to do is to compare it with how a similar situation would be dealt with in US and Europe, to the best of my understanding. Uh, and we'll go through it one by one, and we'll try to understand what is patent eligible subject matter from the Indian context. So when we talk about the general definition of invention in India, the Act defines an invention as something that can either be a product or a process. It does not talk about application of these products or processes or uses of these products and processes. And as a result, any kind of use and claims related to use of a product or process or new use of a known substance or new property of a known substance are not patent eligible in India. Now, as you would fully know, these kind of claims are patent eligible in US and Europe, but this is something that is not eligible in India. The examiners will flat out reject those claims, and they will say that if you have the protection for the product as such or the process as such, your uses or applications are inherently covered by that protection. So we are not going to allow you to have another claim on uses. And that goes that remains the same even if your invention is only on a new use of a previously known substance. Then you are in a danger of getting your application completely challenged by the examiner and may not even get through to the prosecution. Similarly, on method of treatment, that's again something that is an absolute no-no from Indian context. No matter what kind of language you use in your method of treatment claims, whether it's Swiss type, whether it's Euro style, typical method of treating claims, method of managing a disease claim, none of that is allowable in India. A lot of times clients come to us, applicants worldwide come to us and they say, can we tweak the language? Can we modify them? But unfortunately, none of that helps from Indian context. Used to be the case for method of diagnosis as well, but of late we are seeing a bit of a shift in the examiner's mindset in India. The examiners are to some extent okay with allowing claims on diagnosis that are conducted outside of human body. Again, a kind of a direction as to what is being practiced in Europe for many years. Anything where you are able to detect, identify, diagnose in a sample which is taken outside the body, and with the limitation of it being in vitro detection, in vitro diagnosis is being allowed lately. Again, there is nothing, this is not written in law, but by way of practice and by way of certain examiners being a little more accepting of this approach, we have tried this in a lot of cases and have been successful. That's an approach that we always recommend taking when it comes to method of diagnosis, prognosis kind of things. Naturally occurring substances, the situation is very similar to how they treat the situation in the US. A structural difference is a must. Just merely isolating a substance or a compound from its natural environment is not good enough, like it is in in Europe. You have to have a structural, physical, or chemical difference with respect to naturally occurring counterpart. Modified form of a chemical compound. Now, this is the infamous Section 3D of the Indian Patent Act, which means any kind of derivative, salt, isomer, mostly anything where you have a parent small molecule, parent chemical compound, and then you are deriving a new form that from that parent compound is uh, comes under the ambit of this section. And what the patent law basically says is that for these new forms, for these derivatives, you need to show efficacy with respect to the purpose for which the previous compound was used. Now, in cases where you have drugs or in cases where you have compounds that are used for treatment, the efficacy has to be therapeutic efficacy. So you have to show a direct correlation on how this new form, how this derivative is able to treat the disease or disorder better. But when it comes to other chemical compounds, so let's say you have a catalyst or you have an intermediate, then you have to show how this catalyst or intermediate works better with respect to the same purpose for which the parent compound was being used. So sometimes these intermediates, let's say, are used in processes, or catalysts are used to, enhance the efficiency of a process. Uh, you take the same process, you take the same event, same purpose, and show that this new form is able to perform better. So that's what you need to show. And this is kind of an additional burden on top of your regular novelty inventiveness argument, which is why this is sort of a little peculiar from the Indian context when compared to some of the other geographies. On composition of matter claims, again, there's a requirement over and above novelty and inventive step, where you need to basically show synergy and synergistic effect between the components of the composition. So you have to basically show whether your concentrations, components, or a combination of these two is actually making a difference to the composition. It's not that when you're bringing these components together, there is an additive effect, and you're able to arrive at a composition. That's something that you will have to show by way of data. Again, most preferred form of data is to have something in the specification, but sometimes even post-filing data is allowed in that context as well. And lastly, in terms of cells from higher form of organisms, is again something which is not allowed. Only recombinant microbes or microbial cells are allowed. Plant cells, animal cells, even if they are recombinant, are not allowed in India. Again, a slight deviation from how US and Europe sees this. So the only kind of cells that are allowed are prokaryotic cells. And in your claim language, you will have to define that the cell is a prokaryotic cell or an E. coli or whatever the microorganism is. You can't get a claim on just, let's say, a host cell comprising ABC. That will not be allowed. You will have to define what that host cell is explicitly to show that it is not a cell from a higher organism. So that's bit on subject matter eligibility. And now I come to the last issue, which is again something which is peculiar and debated at all times from Indian context. That is claim amendments. Now, in India, there is, especially in the last 5 to 7 years, we've seen the examiners take a very hard position on amending claims in India during prosecution. Now, while the law as such, the written form of law as such, allows claim amendments, even from, from even deriving support from the specification, the interpretation that the examiners at the patent office have is that your amendments should be directly supported by the PCT claim set, by the original claim set, not the specification, the claim set. So, and on top of that, whatever amendment that you make has to be in some form or shape a kind of a correction or a kind of a disclaimer or a kind of an explanation. So it has to fall within the ambit of these three categories, and only then will you be allowed to amend your claim. And that amendment should fall squarely within at least one claim or the claim set as a whole of your original invention, of your original PCT invention, so as to say. So PCT claim set is a kind, forms the basis on which you have to make claim amendments in India. So accordingly, amendments that are exceeding the scope of PCT claim set are not allowable. you also have very limited opportunities to introduce new claims during prosecution. So you have to try and amend the existing claims to show basis again in the original claim set. So that's something that, again, we have had a lot of arguments over the years with the examiners, but something that the examiners are just not comfortable with and just don't allow. And a lot of controllers are also finicky about the total number of claims. So if your PCD claims had, let's say, 15 claims, and now you're trying to make amendments and increase it to 20 claims, they are more likely than not going to have a problem with that approach, and they will say that whatever you do has to be within the total number of 15 claims, and it has to be kind of derivable directly from your PCD claim set. So that's the kind of standard that they follow. Something very peculiar, but something that all applicants need to be absolutely aware of from the Indian context. And therefore, it's important that you have basis in the as filed claim set, have as many fallback positions as possible, as many different aspects that you would want to cover that you believe can come in handy tomorrow, have them in place right at the time of drafting the claims. Sometimes it's also maybe advisable to have different claim set for India and different claim set for other geographies. The official fee for filing patent applications in India and the claim fee is not very high when compared to some of the other geographies. It also doesn't involve any translation. So maybe, just maybe, as a strategy for important applications, you may consider having a slightly different claim set than what you would have for, let's say, US and Europe, which have a cap on the number of claims, and then the fees becomes really high, which is not the case in India. So different strategies to keep in mind when you're looking at claim amendments in India. And yeah, so with that, just ending with this slide, which is generally our best practices that we tend to follow at our firm, and we have received positive feedback over the years from our clients, especially when we are given the responsibility of new filings. We make sure that we have a look at what it is, what kind of claims are sitting in the claim set. Are they all patent eligible or not? Are there issues that are anticipated? So we, in every single case, we go back with a pre-filing opinion, and this is included in the charges, in the cost that we charge for filing the national fees or filing the conventional applications. But it kind of makes the applicant aware of the difficulties that they may face, and they are in a position to take a more informed decision. So we have found this to be very helpful for the applicants, and we therefore have that going for in every case that comes to our firm. That pre-filing opinion will also talk about deletion of certain claims. You might have a claim set which a bunch of claims that might be perfectly fine, but a bunch of claims that might be absolutely not possible to get in India. We will right away recommend deleting those claims to reduce official fee. And for original drafting work, we usually ourselves tend to suggest or incorporate fallback options and anticipate inventive step and eligibility challenges, and try to tweak the draft in such a way that we have sufficient fallback options when it comes to prosecution, especially in complicated matters where patent eligibility is something that we can foresee to be an issue. We have been very honest with our approach, and we usually do not hesitate to warn clients, even if it means a loss of work. And there have been a plethora of clients who've come back and said that they have appreciated our honesty. And even if we have to go back and say, look, you don't have any claim that is possible to get in India, we are okay with that approach, because at the end of the day, clients are important to us, and we want to be as honest as possible with them. We also engage in deep level conversations with inventors, with senior level management on overall IP strategy, whether it's in sync with their business objectives or not, and try to make it a successful win-win situation for our clients. In terms of prosecution, again, a lot of times when there are national phases or conventional applications, instructions do come from our applicants and clients of strategies that they may have taken in other countries. But on top of it, we also try and provide our value adds. any positioning or arguments that can help from Indian context, especially knowing the backgrounds of some of these examiners. We tend to do our bit and help the client on that front as well. We of course have a strong prosecution team backed by experienced litigators, so it's kind of an end-to-end solution for all our clients and applicants worldwide. And as a last pointer to leave you with, we have significant expertise in advisory and opinion work, and we do a lot of search and analysis and opinion work, and all of that is done in-house by our attorneys. So we don't have a separate team, or we don't have a separate third party that we take assistance of for these searches. Our attorneys do it, which means that the quality of search, the quality of opinion and analysis is absolutely top notch and in sync with what you expect to face at the time of prosecution or in courts when it comes to more complex advisory and opinion work. So that's also something that we take a lot of pride in our work. So that's it from my side, and I hope I've been able to leave you with some helpful pointers for your consideration.
The first question is, it seems like we get an immediate rejection for every case we file in India and requires a meeting with the examiner. Why? How can we avoid this expense?
Okay. Thanks, Sharon. It's a nice question. So as some of you may recall, the Indian Patent Office and the patent system in general used to face a lot of flack for being a very laid back office, and it used to take 5, 7, 8 years to get a patent. About 5 years back, the Indian Patent Office underwent an overhaul, and they decided to make some changes in the rules and amendments and so on, which basically brought down the overall timelines for prosecuting a patent application in India. And one of the changes that they made was to take away the second examination report that used to very often get issued in patent applications. So what they have now done is that from the first examination report, they directly move to the next process, which is the hearing. And this is basically a face-to-face chat with the examiner at the patent office. Last 3 years, it has all been virtual. Excuse me. And you basically discuss all the objections that have been pending at the examination report, at the first examination report stage, with the examiner during this hearing, and try to resolve all the previously unresolved objections. And this has brought down the prosecution timelines tremendously in the last few years. How can you avoid this? Well, there's no real sure way of avoiding this, but if you ensure that all the objections are overcome and met at the first examination report stage, when you respond to the first examination report, the chances of you getting a hearing reduces quite a bit. But of course, one cannot guarantee that, and there could still be hearing notices that can be issued, but fear not, it's not a very intense process. It's just a discussion with the examiner that takes place over a period of about half an hour to 1 hour, 1.5 hours, depending on the complexity of the case. And you basically try to bring the case to a closure with kind of amending the claims or discussing the objections with the examiner, and it fast tracks the whole process. So that's where this process has evolved over the last 5 years, in particular in India, and people have found it beneficial because, as I said, these days you are able to get the first examination report and get grants of patent very, very quickly within a couple of years from the time that you file in India. So it's been very helpful in that sense.
Great. We have a second question here. If we sue in India to assert our patent, how likely is it that we would be able to recover our damages?
Yes, so you can definitely sue in India, infringement suits need to be filed at district courts in India. We have basically 3-tier court system that where you can approach the courts for your infringement suits. It's district court, and then high court, and then the highest court of the land, the Supreme Court. Of course, once you file an infringement suit at a district court, if there is a counterclaim for challenging the validity of the patent, then the whole suit gets transferred to the high court. And of course, the validity of the patent is first assessed, followed by the question of infringement. When you the plaintiffs and or the patentees can also request for interim injunction in cases where they are able to make out a case of prima facie infringement, and where they're able to show that the balance of convenience lies in favor of the plaintiff. That means they are likely to face more hardship if an interim injunction is not granted. And then also a showing of irreparable loss or injury definitely helps your case to get an interim injunction. And that is an important stepping stone for you to be able to prevent your competitors from carrying out with the infringement activities. And thereafter, the case proceeds towards a full-fledged trial, and is then finally concluded with either a permanent injunction or awarding of damages or dismissal of suits. So the cases have moved quite swiftly in the last 5 to 10 years in the Indian courts. Most of the bigger high courts in the country have set up specific IP divisions to hear IP cases, and we are headed in the right direction as far as infringement suits are concerned. Of course, India still doesn't have a separate IP court system like some of the other countries, but the existing court system has been able to handle the infringement cases fairly well, and a lot of jurisprudence is being developed at a rapid pace, especially in the last 5 to 7 years. So yes, you are very likely to be able to recover damages and stop your competition from continuing with their infringement activities if you have a strong case.
And the last question we have is, how are plants treated in the India patent system?
Okay, so unfortunately, the Indian patent law does not allow patent protection for plants. You can get patents related to methods, devices, or products that are applicable to plants, but not the plant or their parts as such. You cannot get a patent for that. Even the recombinant cells from a plant, you cannot get those as in terms of patent protection, and therefore there is a separate legislature in India, a separate act which is called Protection of Plant Variety and Farmers' Rights Act, PPVFR Act, and that allows you to get protection for plant varieties, and these could include new varieties, extant varieties, transgenic varieties, as well as essentially derived varieties. So a completely different system of intellectual property exists in India, where you can get protection for your plants as such. But anything to do with, as I said, processes or devices, equipments, products, you can of course apply for patents as you generally do.
Well, I want to thank you, Durgesh, for joining us today.
Thank you, Sharon. It's been a pleasure, and I hope the session was useful.
Oh, absolutely. And thank you, attendees, for your time and attention.